Thank you for using Profile CE Institute to fulfill your CFP Continuing Education Ethics requirement. We strive to offer interesting, timely, and compelling continuing education classes to help CFP professionals get the CE credits they require. You can always check out any of our other classes at www.ce-institute.com. My name is Doug Goldstein, and I am a CFP professional who has been working in the financial planning and investment advisory business for over 20 years. I'm very proud to present this online Code of Ethics course. The learning objective of the Code of Ethics course are as follows. 1. To demonstrate an understanding of and be able to define financial planning, the financial planning process, and financial planning subject areas. 2. To describe the material elements of financial planning. 3. To determine if a CFP professional is providing financial planning or material elements of financial planning. 4. To demonstrate an understanding of the elements of a written agreement when financial planning services are provided. 5. To articulate disclosure requirements and apply disclosure requirements to your practices. And 6. To define and outline elements of the fiduciary standard and know when it applies. Why are these 6 objectives important? Achieving the learning objectives mentioned above, which became part of the CFP Board of Ethics CE program requirements in October 2011, is a very important part of learning ethical behavior and attaining high standards of professionalism. As financial planners, we handle other people's money. To do this effectively, we need to work with a very sensitive and vital commodity, trust. Our clients look to us to give them sensible and profitable advice while minimizing their potential for loss. We're all aware that any losses that clients incur can have life-changing effects. For this reason, it is crucial for CFP professionals to follow the CFP Code of Ethics and Professional Responsibility. Without such predefined ethics criteria upon which to base our decisions, it might, in some cases, be difficult or impossible to give honest and objective financial guidance. Furthermore, it's important to remember that CFP certification is a high professional standard that sets apart dedicated and committed financial professionals from the rest. By studying the standards of professional conduct on an ongoing basis, you're able to live up to the ethical principles and level of professionalism that are expected from CFP certificants and registrants. You can follow the best practice norms of financial planning that are expected of you, and by knowing the disciplinary regulations and procedures used by the CFP board, you'll be able to maintain the required conduct standards more easily. And if you're a candidate for CFP certification, you will gain a greater understanding of the fitness standards that define the character and conduct requirements of a CFP professional. To maintain these levels of professional conduct and competence throughout your career as a financial planner, it's extremely important to take continuing education courses. Indeed, CFP certificants must complete 30 hours of continuing education courses. 2 hours have to be devoted to ethics and the CFP Board's Standard of Professional Conduct. The first learning objective. What are financial planning and the financial planning process? Before we begin looking at the 7 principles of ethics and the practice standards of conduct expected of a CFP professional, we need to understand the first learning objective of this course, the definition and understanding of the concepts of financial planning, the financial planning process, and financial planning subject areas. Although this may seem at first obvious, the CFP Board's Disciplinary Ethics Committee has found that many common violations of the standards of professional conduct appear to stem from a lack of understanding or application of the meaning and definition of financial planning and its material elements. So let's take a look at how the CFP Board defines financial planning when it occurs. The definition of financial planning. Financial planning, as defined by the CFP board, refers to the process whereby a person can meet his or her life goals by managing financial resources in the proper manner. This is a specific process that's integrated within clearly defined financial planning subject areas. You, as a CFP professional, use the financial planning process to help your clients to define their life goals and aspirations and formulate financial plans and decisions in order to achieve them. By doing so, you can build a very special relationship that will go beyond dollars and cents. It's a relationship based on trust, mutual understanding, cooperation, and wisdom. To be an effective financial planner requires skills in decision-making, advanced knowledge, and complete honesty. What is the financial planning process? CFP certificates follow a defined, specific financial planning process that includes some or all of the 6 stages described below in order to create the most effective client-planner relationship. These related and interdependent stages are described at greater length later on in the course as they form the basis of the financial practice standards that must be followed by CFP professionals. Here they are in brief. 1. Defining the client-planner relationship. 2. Gathering client data, including goals. 3. Analyzing your client's financial status. 4. Developing and presenting financial planning recommendations and alternatives. 5. Implementing your recommendations. And 6. Monitoring your recommendations. To understand the importance of these steps and the financial process, let's take a look at a case study taken from the CFP Board's Anonymous Case Histories. This is case number 21547. To make this easier to follow, let's refer to the financial planner as Jane and the client as John. In 2007, the CFP Board discovered a complaint that John filed against Jane and her employee with whom John had a financial planning relationship. Several complaints were made in the letter, but the following allegations specifically relate to what we discussed earlier. 1. John claimed that the investments that Jane had recommended were unsuitable. 2. Jane didn't discuss the fees, charges, or commissions related to a retirement advisor variable annuity that John was interested in. 3. When John asked Jane about any commission associated with the sale of the annuity, Jane replied that she thought it was $1,000, but she didn't disclose this amount in writing. 4. Jane misstated John's risk profile as moderate aggressive instead of moderate conservative. 5. When John told Jane that he wanted to compare long-term care plans, Jane only gave him a single long-term care option. 6. When John told Jane that he wanted to invest in a condo for $145,000 of pre-construction, Jane said it was too risky. 7. Jane invested $100,000 of John's money in a real estate investment trust without explaining how or why the REIT would be appropriate for John's goals. 8. Jane invested almost all of John's money in long-term assets, leaving John with very little liquidity. And 9. Jane ignored John's goals, which were to have income for the rest of his life, to minimize tax payments for his heirs in the event of his death, and to purchase a condo, and to be able to travel. It's clear that these complaints violate financial practice standards, and they also show that Jane did not follow many of the steps of the financial planning process described above. For example, Jane didn't pay sufficient attention to John's goals, as seen by the misrepresentation of his risk profile. When it came to developing and presenting financial planning recommendations and alternatives, Jane only provided John with one long-term plan, even though he had asked for several options so that he could compare them. And though Jane did implement her recommendations and may have monitored them, they were not suitable to begin with, and they didn't serve the client's interests. The CFP Board's Ethics and Disciplinary Commission were also not impressed with Jane's conduct. They ruled that she had violated several ethical regulations, including exercising reasonable and prudent professional judgment in providing professional services, the obligation to act in the client's best interest, and disclosing to the client material information relevant to the professional relationship. Additionally, the Commission stated that Jane had broken the rule of not engaging in any conduct reflecting adversely on her integrity or fitness as a CFP certificant. Therefore, a private censure was issued, and Jane had to complete a further 12 hours of continuing education in addition to the required 30. These credits had to be in various specific fields that were listed by the Commission. From the case study above, we see how important our conduct is as financial planners and how violations of conduct can go against the steps of the financial planning process as well as the financial practice standards to which CFP practitioners choose to hold themselves. For this reason, it is vitally important to understand the nature of financial planning and the financial planning process as mentioned in the learning objectives above. Financial planning subject areas. There are several core subject areas that CFP certificants need to know and apply where necessary. Financial statement preparation and analysis, including cash flow analysis and financial planning and budgeting, insurance planning and risk management, employee benefits planning, investment planning, income tax planning, retirement planning, estate planning. The second learning objective, describing the material elements of financial planning. As I said earlier, one of the learning objectives of this course is to determine if a CFP professional is providing financial planning or material elements of financial planning. As a CFP professional, you need to know whether what you are doing is strictly defined as, quote, financial planning, unquote, or the material elements thereof, because this affects what you need to detail in writing, the relevant disclosures, and the definition of your specific duties towards your client. To begin with, let's look at the meaning of material elements of financial planning and when they are applied. As said above, there are 6 practice standards that form the stages of financial planning. Some of these stages may occur alongside other activities, such as giving investment advice or helping a client make a decision regarding insurance. However, in many cases, you may not need to apply all 6 of these standards at once. The same applies to the core subjects mentioned earlier. One client may seek income tax planning, for example, while another may not require this as part of his financial planning process. The third learning objective. What are you providing? As we mentioned above, the third learning objective for taking this course is to determine if a CFP professional is providing financial planning or material elements of financial planning. To answer this question, you need to examine 2 issues. The first one is the entirety of your relationship with a client, and the second is the degree of integration between the financial planning process and the subjects that you are covering. In its Standards of Professional Conduct, the CFP Board gives the following factors to determine whether an engagement with a client would be considered as financial planning or not. 1. The client's understanding and intentions towards working with the certificant. 2. The level of multiple financial planning subject areas involved. 3. The comprehensiveness of data gathering. And 4. The breadth and depth of recommendations. If the financial planning process is applied to one subject area, it is less likely to be considered as financial planning or of its material elements than if the process is applied to more subject areas. But if your work with the client involves a number of subject areas that are integrated with the steps of the financial planning process, then the service you are providing would be considered to be financial planning. Of course, if you are only working with your client in a single area, your work can also be considered as financial planning, depending on your client's understanding and intentions, the extent of the data you are gathering, and the scope of your recommendations to the client. So, to clarify the nature of your relationship with your client, you need to look at the following questions. 1. Are you involving the steps of the financial process mentioned above in the service you are providing? 2. How many financial planning subject areas are involved to meet the client's goals? And 3, what have you communicated to your client? When you are providing services that involve financial planning or the material elements thereof, your engagement with the client is considered to be financial planning. In this case, the CFP board will consider any future services that you provide to this client to be part of this engagement until your engagement with the client is officially ended. Furthermore, if the engagement between the client and your company ends, but you keep up a professional relationship with this client on an individual basis, your financial planning engagement with him may continue. Of course, it's very important to note that a CFP certificate is not allowed to apply only a single service, product, or subject area at a time in order to avoid having his relationship with the client defined as financial planning or as including material elements of financial planning. To make this a little clearer, the CFP board states in its frequently asked questions on the standards of professional conduct that the following activities are considered as material elements of financial planning. 1. Conducting detailed data gathering regarding multiple aspects of a client's financial situation. 2. Analyzing a client's data and making recommendations across multiple financial planning subject areas. 3. Providing investment advisory services as defined by the applicable state or federal regulators. However, the following would not be considered as material elements of financial planning: opening an account or completing an application, fact-finding to meet regulatory requirements for suitability such as know your customer rules, solely providing brokerage and or insurance products or services, engaging in an activity solely related to the sale of a specific product, acting as a mortgage broker without providing any other financial services, completing tax returns without providing any other financial services, and teaching a financial class or continuing education program. Of course, each client and case is individual, so you would have to decide on the nature of each one based on its own merits. And please note that the method of compensation, whether fee or commission-based, is not a factor in deciding this question. Remember that no matter what kind of service you are providing to your client, whether financial planning or not, you should always uphold the standards of the CFP board and do the best you can to act in your client's best interests. Any questions that arise in this regard may be directed to the CFP board. The fourth learning objective: put it all in writing. The fourth learning objective is to demonstrate an understanding of the required elements of a written agreement when financial planning services are provided. We'll discuss this further on when we reach the specific list of rules of conduct. However, as an introduction, it's always important to remember that the written agreement between the CFP professional and his client should, at the very least, include the following information: the parties involved, the date and duration of the agreement, how and under what terms it can be terminated, and the specific services that will be provided. The fifth learning objective: disclosure. The fifth learning objective of this course is to articulate disclosure requirements and apply these requirements to your practices. As you'll see as we go through the 7 principles of ethics and the practice standards mentioned above more deeply, there are various disclosures that need to be made as part of the financial planner-client relationship. Within the concept of providing a service that's always in the client's best interest, certain disclosures need to be made. Before a CFP professional makes an agreement with a client, he should discuss or offer in writing the following disclosures. 1. The obligations and responsibilities of the certificant and the client with regard to defining goals and needs, provision of necessary data, examining the result of any course of action, drawing up recommendations, putting responsibilities into action, monitoring these actions. 2. Financial compensation for any terms of an agreement. 3. How costs are determined and how the certificant may benefit from any decision. 4. If there are any terms under which the CFP professional could offer proprietary products. And 5. Any terms for using other entities to fulfill any of the agreement's obligations. The case study below, which really happened and is recorded in the CFP Board's anonymous case histories, this one's number 21787, illustrates the seriousness of disclosure in the financial planner-client relationship. In 1995, financial advisor Sam invested $100,000 of his own money in a film company to produce a movie. A month later, he told his client Sarah about an investment opportunity with the same film company. It took the form of a 5-year promissory note for $100,000 that would be paid back to the value of $150,000. However, Sam did not disclose to Sarah that the funds would be used to finance a film production. About 6 months later, in 1996, Sam sued the film company and its president for breach of contract. He demanded to rescind the promissory note agreement, and he wanted full restitution. Sam didn't identify Sarah as a plaintiff in his lawsuit. In 1998, Sam prepared a portfolio appraisal showing Sarah that her investment was now worth $133,000. In 2000, Sam won his lawsuit against the film company, but he was unable to collect the funds awarded. In the same year, Sarah asked Sam to cash in her $100,000 investment. At this point, 5 years after Sarah had invested the funds in this project, Sam told her that the investment was now worthless, the film company was bankrupt, and its president had run off with the funds. He said that he couldn't pay her the high return that he had assured her, and though he promised her that he would pay back her initial investment of $100,000, Sarah didn't see all of the money until she filed an official complaint with the State Securities Division. Sarah also filed a complaint with the CFP board because Sam never prepared a written financial plan for her, and he also abused the CFP marks, which is a separate offense. Needless to say, Sam had his right to use the CFP marks revoked permanently. While it was not Sam's fault that the film company was dishonest, where he went wrong was by not disclosing important information to his client. He didn't tell her the true nature of the investment, making a film, and the risks involved, and he didn't tell her about his lawsuit or include her as a plaintiff until Sarah wanted her money back. And although he later denied these claims and said that he did apprise her of all of the facts, he had no written proof of his alleged disclosures. And by not disclosing all of the necessary facts, Sam did not act in his client's best interest, and he ended up losing his rights to practice as a CFP professional. This is a very good example of why understanding the need for disclosure is an important part of our learning objectives. The sixth and final learning objective, the fiduciary standard. The sixth and final learning objective, as mentioned earlier, is to define and outline elements of the fiduciary standard and know when it applies. What does this actually mean? In addition to adhering to the CFP board's standard of professional conduct and code of ethics, a CFP professional must act as a fiduciary. A fiduciary is defined as a person who acts in good faith in the way that he or she considers to be in the client's best interests. This means understanding the client's goals and needs and current financial situation, and with this knowledge, seeking the best possible options for the client. As we will explain in greater detail later on, a financial planner must make all recommendations based on professional judgment and what will benefit the client most. Here's a case study taken from the CFP Board's anonymous case histories. This is case number 19075, showing how important it is to act as a fiduciary in good faith and what this essentially means. In May 2005, financial advisor Mary met with her client Jake and his elderly father, Bert. During their meeting, Mary made an oral agreement to handle Bert's finances. Mary, Jake, and Bert didn't sign any written agreement, and Mary didn't complete a client profile for Bert, which is a clear breach of defining the client-planner relationship, the first step in financial planning as mentioned above. 2 months later, in July 2005, Bert followed Mary's advice and liquidated his personal savings account worth $25,000 and wrote a check for this amount to Mary's company. Mary cashed the check, but she didn't create a separate account for Bert. Bert continued to follow Mary's advice, and he liquidated his money market account containing $11,000 and gave the proceeds to Mary to manage. In January 2006, Mary opened an escrow account on a deed of trust in the amount of $47,000 using a check made out to her and her company, even though Bert didn't authorize the opening of the escrow account. Bert eventually stopped receiving monthly distribution payments from a broker-dealer acting as custodian of his assets because Mary failed to fund the account properly. Furthermore, Mary offered to make recommendations for Bert's current living trust. Without being asked, she went ahead and drew up a will, revocable trust, and power of attorney for managing Bert's property and personal affairs. Even though Bert didn't request these documents, Mary charged him the sum of $400 per hour for preparing them. And when Bert asked her to provide him with all of the documents related to his investments, she never did. In May 2006, Mary gave a check to Bert for $23,000 and said that she was withholding $12,800 as a fee for the services she had provided for him and her client, his son Jake. All of the above occurred even though Mary was never officially appointed as Bert's financial planner. Of course, there were various violations of the Code of Ethics and Practice Standards in this particular case. But with regards to breaches in fiduciary standards specifically, you can see how Mary didn't act in good faith at all. Jake, as her client, had trusted her to work with his elderly father, Bert, but their verbal agreement didn't mean that she was now his advisor. Good faith should have meant building a relationship of trust by drawing up a clear, definite written agreement, including goals and plans, and how to implement them in Bert's interests. In addition, as well as violating the fiduciary standard of acting in good faith, Mary also breached the standard of acting in the client's best interest. Instead, she commingled funds, didn't fulfill Bert's goals, and acted independently rather than at his request. She clearly violated the practice standards that states that a CFP practitioner should handle investments, quote, with the care required of a fiduciary, unquote. So remember, you must always have the client's best interest in mind, and when providing financial planning or its material elements, you always need to give your client the care of a fiduciary as defined by the CFP board. As a fiduciary, you want to offer and deliver only the financial planning recommendations, services, and products that you believe are the best possible options for your client. But as there are so many financial products and services available, it may at first seem impossible to evaluate all of the options. And what if you work in an arena where the products and services that you can offer are regulated or limited? How do you know if you are meeting the required fiduciary standard when you provide financial planning? Are the options that you are offering really the best for your client? The answers appear in the fifth learning objective above, the need to articulate disclosure requirements and apply them to financial planning practices. As a qualified CFP certificant, you follow certain strict standards and norms that you must apply to your client's situation. These standards guide you towards finding out what is in your client's best interest. Furthermore, the standards you have learned require you to disclose any business or regulatory requirements that may affect or limit your engagement with the client. All of these factors need to be outlined in written disclosures, as I'll explain a little further on. The 7 principles of ethics. Now let's discuss the Code of Ethics itself. The CFP board designed its Code of Ethics based on 7 basic principles. By understanding these underlying concepts that went into creating the Code of Ethics, you'll be able to apply these ethical principles more effectively. When we reach the section of the course that deals with practice standards, I'll tell you which of the principles each individual standard relates to. Let's take a look at these 7 fundamental principles step by step. Principle 1, integrity. The very first principle of the CFP Board's Code of Ethics is integrity. Integrity means that you should always be honest and never allow your decisions and opinions as a financial advisor to be affected by your personal gain. Your clients need to know and to feel that you are constantly acting in their best interests and that they always come first. For this reason, aside from your professionalism, your personal integrity is your greatest asset. Therefore, if your clients ask questions about what you will provide for them or want to know what's going on with their portfolios, vague answers will not build up a relationship of trust. Instead, Clearly tell them what you are doing and what services they are paying for. Take the time to explain the little details and the small print. This will show them that you are honest and not hiding anything from them. Explain to them why you made certain choices, and they will see that your actions are motivated by their best interests. Innocent error or legitimate differences of opinion happen every day in our profession. But if you are honest and straightforward with your clients, they will not just remember the fact that you are, after all, only human, but that you are open and trustworthy. Maintaining your standards as a certified financial planning professional means that you must work with integrity at all times. Principle 2, objectivity. Objectivity is the stage that follows integrity. As your main purpose is seeking what is best for your client, all of your decisions should be viewed as objective and as impartial as possible. By assessing the situation from all points of view, you provide your client with the optimum possible service. Follow the path of intellectual honesty as far as you can. Principle 3, competence. In the context of financial planning and advice, competence essentially means attaining and maintaining an accurate level of knowledge and skill, and then applying it to serving your clients. Displaying a high level of competence reassures your clients and builds up their trust and confidence in you. Another aspect of competence is being aware of your limitations. If your client's situation is beyond the scope of your skills or level of knowledge, bluffing your way through and hoping for the best will at best not be helpful, and at worst could cause serious damage. Instead, you should recognize your limitations and either consult with another professional or refer your client to the relevant authority. Clients will sometimes ask questions to which you don't necessarily know the answer, especially in the area of taxes. You need to let them know that you're not the right address for these queries if you're not an accountant or a qualified tax professional. Don't try to pretend to be something that you're not. At the same time, when it comes to the fields that you do work in, you need to make sure that your knowledge and skills are constantly up to date in today's changing world. It's not enough to receive official certification. You should constantly keep your finger on the pulse of the latest developments. Keep attending courses and seminars regularly. Read professional literature, and always try to be aware of what's going on. By honing your abilities and knowledge, you will sharpen your level of professional competence. Principle 4. Fairness. The previous principle, objectivity, implies that you should handle a situation unhindered by personal feelings or interpretations. Principle number 4, fairness, takes this step further. Fairness is defined by Webster's dictionary as being marked by impartiality and honesty, free from self-interest, prejudice, or favoritism. One very important aspect of fairness is conforming to the established rules of business. In the world of a CFP certificant, this means disclosing any material conflicts of interest and then subordinating your own feelings and prejudices and desires so that you can achieve the correct balance that best suits your clients. This principle is one of the main tenets of dealing fairly with clients. In other aspects of your life, I'm guessing that you would choose the professionals that you would prefer to work with you quite carefully. You would look for a professional who knows his job very well, is up to date with the latest developments, has your best interests at heart, and is very pleasant to do business with. In the same way, if these are your requirements when choosing a professional, these are the qualities that you should be prepared to display to your own clients. Principle 5. Confidentiality. Revealing personal or professional information about clients and their dealings without their permission can be extremely damaging. Not only is this an unpleasant thing to do in general, but depending on the situation, it can harm a client professionally as well as personally. The misuse of information can lead to legal violations in certain cases. And, of course, this is without mentioning the bad feelings caused when a client finds out that his or her confidentiality has been breached. This could irrevocably damage your relationship with the client. Think back to your school days. The friend that blabbed all your deepest secrets to the rest of your classmates didn't remain your friend for very long. You quickly learned never to mention anything else that was private to that person because you did not want the whole world to know. Clients feel the same way about their financial advisor. Therefore, always remember that in order to build up a relationship based on trust, client confidentiality must be maintained at all times by you and anyone who works for you or with you. Make sure that all of the information that you have is only accessible to yourself and other authorized individuals. Principle 6. Professionalism. True professionalism is not only about how you project your image to your clients. It also requires treating your clients, colleagues, and anyone else that you come in contact with in the course of your business with courtesy and dignity. By cooperating with your clients and colleagues and providing the best service that you can, even when you're having a bad day, you will create a positive image for yourself and the profession as a whole. Honesty, politeness, and efficiency will do far more for your business and personal reputation than fancy gadgets, snazzy brochures, and showing off. Principle 7. Diligence. In terms of a business contract, diligence means being conscientious that the terms of the contract that you have with your client are fulfilled with all of the attention and care that is required. For a CFP professional, this means that you must do your best to provide your services in a reasonably prompt and efficient manner. Spend time to get to know your client's personal and financial goals. Don't rush through the preparation of the financial plan or investment strategy, nor through meetings and phone calls. Make sure that every service you provide is properly supervised and carried out. Rules of conduct. The rules of conduct that I am about to discuss are binding upon all CFP professionals. They're vital for establishing and maintaining a high professional standard. Because the world of financial planning is so diverse, you may well find that some of the rules described here don't apply to your particular sphere of influence. That being said, you must take care to ascertain which rules do apply to you, and then do your very best to keep to them. If a CFP professional violates these rules, he may be subject to discipline and could possibly lose the right to use the CFP trademark. These rules, however, are not designed to be a legal basis for liability to any third party. Rule 1. Defining the relationship with the prospective or existing client. To fulfill the role of a financial planner properly, the first thing that needs to be done is to define the criteria and nature of your relationship with your client. So, the first rule of the CFP code is the CFP certificant and prospective or existing client should mutually agree upon the services to be provided by the certificant. For a financial planner to build a successful relationship with his clients, the following issues need to be discussed early in their relationship. The obligations and responsibilities of each party under the agreement with respect to 1. Defining goals, needs, and objectives. 2. Gathering and providing appropriate data. 3. Examining the result of the current course of action without any changes being made. 4. The formulation of any recommended actions. 5. Implementation of responsibilities, meaning who should do what. And 6. Monitoring responsibilities, meaning who will keep an eye on what. Other important issues for the professional planner to consider are, first, the issue of compensation. This includes the factors and terms that determine the cost, how much these decisions benefit the CFP professional, and in which way. Second, the terms of the contract that would allow the CFP professional to offer his client proprietary products. Proprietary products are additional services that his company exclusively provides and may not be available elsewhere. And third, the conditions under which the CFP professional might use other entities to fulfill the terms of the agreement. This may include the use of a money manager or consultation with an accountant or tax professional. You should encourage your clients to read all written information carefully and recommend that they ask questions. Always answer your clients' inquiries openly, honestly, and clearly. Once you have agreed on these terms, they must be put into a written agreement between the financial planner and his or her client. After you have clarified and agreed upon the terms with your client, you must put them all down in a written agreement. This agreement should include the following points: the parties involved, the date and duration of the agreement, how and under what terms it can be terminated, the specific services that will be provided. This agreement can consist of a number of written documents used by the CFP certificant or his or her employer. As long as these forms include the conditions given above and comply with federal or state regulations and conform to the rules of a self-regulatory body, this is acceptable. The first rule, defining your relationship with the client, should always conclude with putting your client's interests ahead of your own. Remember that your role is to implement the needs of your client, and his benefit should always be paramount. In fact, a CFP certificant always owes it to his client to provide the care of a fiduciary as defined by the CFP board. Rule 2. Information disclosed to prospective and existing clients. You should always endeavor to be upfront with your clients and provide them with accurate information. The facts you give must be correct and should not, either directly or indirectly, mislead the listener with regard to your qualifications or the services that you provide. Never confuse anyone about the potential benefits of these services. Always be sure to disclose all relevant information that is necessary so your clients do not have misunderstandings. As a CFP professional, you should give prospective and existing clients the following information: a current and accurate description of your compensation arrangements. This should include your cost and compensation, the terms under which you or your employer can receive compensation from other sources, and the sources of such payments. A summary of any likely conflicts of interest between you and your client or other third parties. For example, if your employer happens to be your mother or you work closely with your uncle's company as a legal affiliate, you must disclose this family connection. The same applies to any contractual or agency relationship that could have a material effect upon your connection with your client. You need to disclose any information about you and or your employer that might materially affect the client's decision to use your services. For example, if your prospective client is divorced and you happen to be currently working with the ex-spouse, you would be expected to disclose this information only after getting approval from the ex-spouse to divulge his or her name. You obviously must also give your contact information and, where applicable, that of your employer, and, as above, all of this information should be in writing and can consist of several documents. This documentation is acceptable if it contains all of the information listed here and complies with state or federal law or the criteria of a self-regulatory body, such as the Securities and Exchange Commission's Form ADV. All disclosure documents must satisfy the requirements of this rule. It's of prime importance that whenever the aforementioned information changes, you should inform your client as soon as possible. Rule 3. Prospective and existing client information and property. Complete confidentiality of information is a very important CFP rule. All client information has to remain absolutely confidential. Although this rule is extremely important, there are some exceptions to it. Confidential information may be supplied if it is needed in response to a proper legal process or to fulfill an obligation to the certificant's partner or employer. It can also be disclosed if necessary to defend against charges of wrongdoing in connection with a civil dispute or to expedite the proper execution of the CFP's professionals' services. Nonetheless, to ensure confidentiality of information, you must take every necessary step to protect the security of any stored data, whether electronically or physically. So, you're probably asking at this point, exactly what information are we talking about here? First of all, this relates to every piece of information that is necessary for fulfilling your obligations. All of the information must be gathered And if anything is lacking, you must inform your client of all material deficiencies. Secondly, you need to identify the specific assets over which you will take custody, exercise investment discretion, or have supervision. Keep comprehensive and complete records of all of the client's assets and property that have been placed in your custody or under your discretionary authority. At this point, we should mention the famous Shakespearean quote, "Neither a borrower nor a lender be." Rule 3 includes the requirement that a CFP certificant should never borrow money from his client. This would be a major breach of professionalism that could seriously damage their working relationship. The only exceptions to this rule are 1, if the client is a member of the certificant's immediate family, and 2, if the client works for an institution that lends money and the loan is unrelated to the professional service being provided. It should also be said that all of the above also applies in the reverse situation. A client should not borrow money from a CFP professional unless the situation is one of the exceptions mentioned above. Another important rule regarding property is that the CFP professional should never combine his client's property with his own or with that of his employer unless this is permitted by law or specifically written in the agreement between the two of them. The same applies to commingling one client's property with that of another. This is also explicitly prohibited unless there is a specific written authorization from each client and you keep proper track of whose assets are where. Another important point to remember is that you should always return a client's property to him upon his request as soon as you can or within the specific time frame given in a written agreement between the two of you. These clear borders must always be maintained throughout your working relationship. Rule 4. Your obligations to your prospective and existing clients. You must always provide your clients and prospective clients with a professional service and understand their needs. Integrity and objectivity should be your watchwords. This includes providing clear and objective advice to your clients. However, you should only offer advice where and when you are competent to do so and consistently maintain your level of competence in all areas of your professional life. Essentially, this means that you should not try to bluff your clients by advising them on subjects that you know very little about. It is better to be upfront and say that you don't know enough about the issue to give concrete advice, if that is the case. In addition, you should always be looking to increase your existing knowledge and ability in order to maintain your level of competence. If at any point you need to assign responsibility for any of your services to a third party, you must always provide capable and prudent supervision over that party's activities. And if, for any reason, your certificate from the CFP board is either revoked or suspended, you have a responsibility to inform your clients of that fact. Rule 5. Your obligations to your employers. As an employee, you also have obligations to your employer. These are 1. To follow your employer's or firm's lawful objectives, and 2. To follow the CFP Board Code of Ethics. Just as your client needs to be aware of your status, it is your obligation to also inform your employer if your CFP certificate is either revoked or suspended. Rule 6. Your obligations to the CFP Board. Your obligations to the CFP Board are pretty straightforward. You need to follow all of its requirements for using its trademark, and you must cooperate fully with its regulations. To continue using the trademark, you need to follow CFP's continuing education requirements. If your contact information, such as your email address, business or home address, or telephone numbers change, you need to notify the CFP board within 45 days. If you are convicted of any crime, aside from a traffic offense, unless the misdemeanor involved alcohol or drugs, or you are given any professional suspension or bar, it is your duty to inform the CFP board within 10 days. Needless to say, a CFP certificant should not engage in any behavior or pastime that would reflect negatively on his or her integrity as a certificant, or upon the CFP board or the profession in general. Until this point, we have been discussing the 7 principles that guide the CFP Code of Ethics and the 6 rules of conduct that a CFP certificant must always follow. While these regulations and principles may seem self-evident to many an advisor, the CFP Board Code of Ethics is written out to serve as a resource for times when advisors might face conflicts of interest and need guidance as to what the correct behavior is. As life is often complicated, there may often be situations where a CFP professional needs to refer back to the regulations to find out what the correct ethical stance is on a given situation. Adherence to the Code of Ethics and its rules ensure the good name of the profession as a whole and your professional standing in particular. Continual education, such as this course, is an integral part of upholding ethical behavior in the financial planning profession. It is up to CFP certificants to remain steadfast in providing diligent, integral, and quality services. Financial practice standards. Let's now take a look at the practice standards that are expected from a certified financial planner. Your first question here may be, what is a practice standard? Before, we were discussing the what, meaning the code of ethical standards laid down by the CFP board and the rules to which they apply. At this point, we are now to discuss the how of professional ethics. By simple definition, a practice standard determines the level of professional practice expected from certificants engaged in financial planning. Practice standards ensure that CFP professionals work within established norms of practice, advance the level of professionalism in the field of financial planning, and enhance the value of our work. To make the relationship between these standards and the Code of Ethics easier to understand, I will also mention the specific fundamental principles to which each standard relates. Practice standards apply to any CFP professional working in any aspect of financial planning, regardless of job position, method of payment, or type of employment. They provide a framework for the professional practice of financial planning, but like the rules of conduct that we described earlier, they are not designed to be a basis for legal liability to any third party. The CFP Board was founded in 1985 in order to set high standards among financial planners by creating clear certification, maintaining continuing education, and enforcing the need for experience and defined ethics requirements. The CFP certification process increases levels of competency in the financial planning profession. To take this further, the CFP Board founded a Board of Practice Standards. The members of this board are exclusively CFP professionals who have been given the job of drafting practice standards for the financial planning profession. These practice standards have since been revised, and these are the standards that we follow today. As financial planners, we must work according to these practice standards. The CFP Board's Disciplinary and Ethics Commission uses them to assess whether the rules of conduct have been violated. Many of the practice standards cannot stand by themselves, but are closely dependent and intertwined with others. For a CFP certificant to fully uphold the Code of Ethics and Professional Behavior, he must implement all 6 practice standards in his client interactions. Standard number 1, defining the client-planner relationship. Before you begin providing a service to your client, you need to mutually define the exact scope of the engagement between you, spelling it out unambiguously to prevent any dispute. This is accomplished by doing the following: identifying the services to be provided, disclosing the professional's possible conflicts of interest, disclosing the professional's compensation arrangements, determining the client and professional's responsibilities, establishing the duration of the engagement, and providing any additional information to either define or limit the scope. The scope of your activities should refer to several subject areas of financial planning. Where your activities are limited to certain areas, these must be clearly defined. This helps to make the expectations of both the professional and the client more realistic. Although not all of these must be set down formally in writing, certain disclosures may need to be written out. As the relationship with your client grows, certain flexibility may be required, and changes that are mutually agreed upon can be made to the scope of your financial planning activities. This practice standard is related to Principle 4 of the Code of Ethics mentioned above, which is fairness, and also Principle 7, which is diligence. By following all of these rules, the client's expectations are more likely to be achieved. The financial planner will also find that it makes his job easier, as all of the tasks and goals will be clearly defined. Standard number 2, gathering client data. Determining the client's personal and financial goals, needs, and priorities. You need to ascertain the personal and financial goals and needs of your clients in order to make a success of your professional relationship. This should be done before any recommendation is either made or implemented. To evaluate these goals, you need to be a bit of a psychologist. Explore your client's attitudes, values, expectations, and time horizons in relation to fulfilling goals, needs, and priorities. Answering these questions with your client is essential for determining which activities are necessary in order to proceed with your engagement. The client's attitudes and personal values are what shape these goals and their priorities. Goals and objectives must be clear. It is best if they are measurable, although some aspirations can never be laid down in exact facts and figures. Build this picture together with your client. At the same time, be honest and open. There may be times when you need to help your client in recognizing when their objectives are unrealistic and what the implications of such goals would be. There's no point in spending valuable time and energy on an aspiration that you know from the outset is unrealistic or unattainable. Remember, this practice standard only addresses the tasks of determining your client's goals, his attitudes, and timeframes. All of these areas are subjective, and your interpretation depends on what your client is willing to disclose. For this reason, this practice standard can't be considered on its own, but only in conjunction with other practice standards. This practice standard upholds the principle of serving the client's best interests and increases the likelihood of achieving his objectives. It also encourages the public to use a financial professional who has such approach. This practice standard is connected with Principle 7 of the Code of Ethics, diligence. Obtaining quantitative documentation and information. Before any recommendation is made or implemented, the financial planner should gather enough relevant information and documentation for it to work properly. To get the best result, proceed as follows. Determine which information and documentation are sufficient and necessary based on the scope of the services provided. Information gathered should be related to the client's financial resources, obligations, and personal situation. Obtain information directly from the client or from interviews, questionnaires, client records, and documents. As the financial planner, explain to the client the need to acquire complete and accurate information. Discuss the effect of incomplete or inaccurate information upon conclusions and recommendations. But what do you do if you can't get enough relevant information upon which to build a recommendation? Then your choices are either to restrict the extent of the engagement to whatever information you do have at your disposal, or to cancel the engagement entirely. You should explain any limitations to your client, including the potential effects of incomplete data upon the scope of the service provided. Again, the point of this practice standard, which should never be considered on its own, but as a part of the other standards demanded, is to improve the efficiency of your service and the likelihood of achieving the client's goals. As gathering information is a vital part of the financial process, and the public realizes this, Potential clients are more likely to choose planners who follow this practice standard. This practice standard relates to Principle 7 of the Code of Ethics, diligence. It should not be considered on its own, but must be followed along with the other practice standards. Standard number 3, analyzing your client's financial status. No matter how easy or difficult it has been to get hold of the relevant information, once you have it, you need to analyze it. Use it to gain an understanding of your client's financial situation and evaluate to what extent his goals and needs can be met with the resources and information that you have at your disposal. The assumptions and information that you gather from the client are both personal and financial and should include the following: personal assumptions and facts such as age, closeness to retirement, life expectancy, income needs, risk factors, time issues, goals, and any special requirements. And economic assumptions such as inflation, tax rates, assets and expenses, and investment returns. By regularly updating this information, you can determine whether the scope of the plan should be changed or whether additional information is necessary. This kind of analysis and evaluation is absolutely vital to your role as a financial planner. By being fully aware of your client's situation, strengths, and weaknesses, you can work out the course of action that you need to take in a much more efficient manner. This practice standard relates to Principle 2 of the Code of Ethics, objectivity, Principle 3, competence, and Principle 7, diligence. Standard number 4, developing and presenting financial planning recommendations and alternatives. This standard can be described as the heart of financial planning. Now that you have all of the relevant information, you have to apply it by using a combination of science and art to work out the recommendations that would best achieve your client's goals and needs. With financial planning, this whole process is not a single task. It can actually be divided into 3 stages. 1, what is possible. 2, what is recommended. And 3, how is it presented. The first 2 stages of what is possible and what is recommended require a lot of creative thought and analysis. This is usually done as your homework rather than being worked out in the client's presence. Let's take a closer look at these 3 steps. Step 1, identifying and evaluating financial planning alternatives. As a financial planner, you need to look at sufficient and relevant alternatives to your client's current course of action in order to find the best way to reach the client's needs and objectives. This means considering multiple assumptions, consulting with other professionals, and conducting thorough research. As a result, you may find one good alternative, 10 alternatives, or maybe nothing better than what your client is doing already. When making this analysis, it is vitally important to take into account your own legal and regulatory limitations and level of competency in being able to handle your client's financial planning issues. Aside from finding more than one suitable alternative, you may also discover that your suggested ideas differ from those of your colleagues. We can see from here the subjective nature of exercising professional judgment. This practice standard relates to Principle 2 of the Code of Ethics, objectivity, Principle 3, competence, Principle 6, professionalism, and Principle 7, diligence. Step 2, developing financial planning recommendations. You have to take the results of your research and turn them into a viable course of action. A recommendation may be one independent action or a combination of several that are implemented collectively. When making a recommendation, you should take the following points into account: the mutually defined scope of the engagement, mutually defined client goals, needs, and priorities, quantitative data, personal and economic assumptions, your analysis and evaluation of your client's current situation, and the various alternatives that you have selected. Of course, you may decide, as we said earlier, to simply continue following your current course of action. Any particular changes might be detailed and very specific. And then again, you may suggest to your client the need to modify a goal. even if your recommendations differ from those of other CFP professionals. The main thing is that they effectively meet your client's goals and needs. This practice standard relates to Principle 2, Objectivity, Principle 3, Competence, Principle 6, Professionalism, and Principle 7, Diligence. This practice standard benefits the public because each client's needs, goals, and priorities are met more easily. However, it also has a positive impact on the financial planning profession in general because the development of customized strategies and recommendation gives a favorable impression to the public. If potential clients can see that financial planners are objective and fair in their recommendations, they are more likely to seek out those individuals who follow these practice standards properly. Step 3. Presenting your recommendations to the client. Now that your recommendations are clear and set out properly, you need to present them to your client. Good communication here is essential. You must inform your client of your suggestions in an explicit manner so that he or she can then make a well-informed decision. Make sure that your clients understand the situation, the actual recommendations, and their impact upon their goals and needs. And remember to clearly state that this is your opinion rather than hard fact. Here are the most important points to speak about with the client. Personal economic assumptions, the interdependence of multiple recommendations, advantages and disadvantages inherent in each potential choice, risks, and time sensitivity. Don't forget to tell your client that these suggestions are not written in stone. Any significant economic and personal change could alter their outcome. These might include the actual changing of existing laws, swings in performance of current investments, or shifts in family status, career, or health. At this point, if there are any conflicts of interest that have not yet been disclosed, this is the time to mention them and to discuss how they may affect the recommendations that you have given. When presenting your recommendations to your client, you have a chance to assess how he actually feels about your ideas. A face-to-face meeting is better than a phone meeting since it provides the opportunity to judge body language. You can also gauge with greater clarity whether he feels these suggestions meet his expectations, whether he wishes to act upon them, and whether any modifications are necessary. This practice standard is connected to Principle 1 of the Code of Ethics, which is integrity, Principle 2, objectivity, and Principle 6, professionalism. This particular practice standard benefits the public because presenting clear recommendations to the client makes it easier to achieve his goals. Moreover, the client will have more confidence in the objectivity and value of financial planning. When the financial planner customizes his strategies and recommendations, it creates a firm foundation for communicating meaningful and responsive solutions, further increasing client satisfaction. Standard number 5. Implementing your recommendations. After you've accumulated all your information, analyzed it, developed your recommendations, and presented them to your client, your next move is to put all of the recommendations into practice. The best way to do this is to make them as simple as possible. To do this, you should first of all sit down with your client and mutually work out which responsibilities each of you will take on to implement your recommendations within the scope of the engagement. The client, for example, is responsible for accepting or rejecting recommendations and for retaining or delegating various responsibilities. You and your client should agree between you exactly which services you will be providing. The scope of the engagement may also need to be modified. Here is a possible list of responsibilities for the financial planner. Needless to say, this list is subjective and can certainly be changed. Identifying activities necessary for implementation. Determining the division of activities between the planner and the client. Referring to other professionals. Coordinating with other professionals. Sharing information where authorized. Selecting or securing other products or services, and making sure those providers will serve your clients with the highest level of integrity. If you suggest other professionals or advisors to implement any aspect of your recommendations, you need to indicate and explain clearly why you think they are qualified for this role. Furthermore, if there are any conflicts of interests, sources of compensation, or material relationships with any of the recommended advisors, this is the time to raise them. This is also the point where you, as the financial planner, define the exact extent to which you will rely on the information, analysis, or recommendations provided by other professionals. This practice standard is connected to Principle 3, competence, Principle 4, fairness, Principle 6, professionalism, and Principle 7, diligence of the CFP Board's Code of Ethics. Before supplying any products or services to your client, you must make sure that you only provide what is most appropriate in line with his needs and goals. There are many products and services out there. Some may differ from those that your fellow professionals offer. There also may be more than one option that would benefit your client. The most important consideration has to be which one is the best and most suited to my client's needs. Bear in mind the need to be thorough, precise, and cautious before you come to a final decision. When making your decision, use your professional judgment to assess whether the products or services that you are considering are really in your client's interest. This includes analyzing quantitative and qualitative information. Also, keep an eye on regulations mandating any particular disclosures, because this is the time to make them. This practice standard relates to Principle 2, objectivity, Principle 4, fairness, Principle 6, professionalism, and Principle 7, diligence of the Code of Ethics. Implementing this standard will serve the client's best interest and improve the likelihood that his goals will be achieved. It is also important to remember that putting the client's interest first always benefits the financial planner over the long term. Standard number 6, monitoring the recommendations. Defining monitoring standards. What part does a financial planner play in the monitoring process? Does your client want you to take responsibility? Your role in the process of monitoring ought to be clarified right from the start. Doing this ensures that your client's expectations are in line with the level of monitoring standards that you are able to provide. If your client does not want you to assume a monitoring role, you need to be clear about what is expected of you, how you feel in this regard, and with which aspects you can and are willing to comply. Explain what exactly you will be watching and how you will do this, how often you will review and monitor the account, and finally, discuss and agree upon a mutually suitable method of communication. This prevents misinterpretations and gives the client a better understanding of what is going on. You and the client should mutually define your monitoring standards to avoid mistakes, oversights, and thoughts or accusations of bias or partiality. You may find that the monitoring process will reveal that certain steps of the financial planning process need to be reinitiated, or that the scope of the whole framework needs to be redefined. This is why defining monitoring standards and responsibilities is so important. This practice standard is connected to the CFP Board's Code of Ethics Principle 7, diligence. It assists the creation of client satisfaction and clarifies the responsibilities of the financial planner. Disciplinary rules and procedures. Now that we have read the rule book and learned what is required of a CFP professional, the time has come to look at what happens if the above-mentioned Code of Ethics, principles, and practice standards are not followed. As we said earlier, rules of conduct and practice standards are vital components of the services that we provide and the relationships that we form. Another equally important part of our service to the public and to our clients is discipline. This provides the checks and balances that keep our standards in place and help us to accomplish more. The CFP Board has the right to enforce its standards, and any violations will be disciplined. Let's find out what this actually means and what actions are considered to be violations. We will also find out what disciplinary actions are taken in order to enforce the CFP Code of Ethics and Practice Standards. The Disciplinary and Ethics Commission. The CFP's Disciplinary and Ethics Commission has the responsibility and duty to review and take action in the case of any violations or breaches of the CFP's rules of conduct and practice standards. The Commission will have original jurisdiction over any disciplinary issues. What are the powers and duties of this Commission? Here are some of the main ones. At least once a year, the Commission reports on its operations to the Chief Executive Officer and the Board of Directors of the CFP Board. The Commission proposes and suggests to the CEO any necessary changes to the disciplinary rules and procedures. These ideas are then subject to the review and approval of the Board of Directors. The Commission recommends to the CEO any other appropriate rules or procedures that should be instituted. The Commission provides recommendations and input to the CEO regarding the selection of possible members of the Commission, as well as volunteers who serve in a temporary capacity on a hearing panel. The Commission evaluates the performance of those volunteers during hearings. At the Commission's annual summer meeting, a Commission chair is recommended who will then serve during the following calendar year. Recommendations are made where necessary to the CEO with regard to any proposed rules to the probable cause determination process. At this point, you may be wondering exactly who this CEO is and what this busy-sounding person has to do. The duties of the CEO include the following: to appoint the Commission chair, volunteers, and members, to oversee the Commission's activities, to make sure that everyone is treated fairly, to supervise a hearing panel and to make sure that it is comprised of impartial, objective members who have no conflicts of interest with any of the parties involved. And the CEO must also conduct background investigations of prospective members and volunteers of the Commission. The hearing panel. What is a hearing panel? A hearing panel is a body that reviews complaints against certificants. It consists of 3 people, 2 CFP certificants, and a volunteer. One member of the panel also serves as the chair of the meeting. He has to be a member of the Commission. The chair rules on all objections and motions presented before or during a hearing. So, what would you do if you were a member of the Commission and you were asked to be on a hearing panel that would be reviewing a complaint against your favorite niece? Or, what if the complaint was against your business associate? The answer is that Commission members are not allowed to participate in any proceeding that involves a member of their immediate family or their firm, or where their participation could lead to a conflict of interest or even have the appearance of an impropriety. A tale of 2 attorneys. 2 different attorneys are involved in the hearings. The CFP Board Counsel, who presents the case to the hearing panel, and the CFP Advisory Council, who acts in an advisory capacity in providing advice on the standards of professional conduct and hearing procedures to the hearing panel. No one person should act as both CFP Board Counsel and CFP Advisory Council during the same set of meetings. Question: where are these hearings held? Unless the Board of Directors gives its specific approval, the headquarters of the CFP Board are where all investigations, coordination of investigations, and disciplinary enforcement procedures into the conduct of CFP registrants are held. All prosecutions of charges and any other similar activities are also held there. Grounds for discipline. Now that we have discussed who is responsible for discipline and the enforcement of the CFP Board's standards and code of ethics, what are the grounds for disciplinary action? First of all, any misconduct by a CFP professional, whether individually or with others, may be cause for disciplinary action. This takes into account all of the instances that I am about to give, whether or not the specific act or omission occurred in the context of a client relationship. These include any act or omission that violates the rules of conduct, any act or omission that fails to comply with the practice standards, any violation of state or federal criminal law. However, please note here that a criminal conviction is not a prerequisite for a disciplinary proceeding, and an acquittal in criminal proceedings does not bar disciplinary action. Any act or omission that violates the CFP Board procedures, failure to respond to a request from the Commission without giving a good reason, or obstructing the Commission or a similar panel in its course of duty. A good cause includes asserting that a response would violate the certificant or registrant's constitutional privilege against self-incrimination. And finally, any false or misleading statement made to the CFP board. Please keep in mind that this list is not exclusive. Any other type of unprofessional conduct may be added to this roster at any time. Forms of discipline. If the Commission decides that there are no grounds for discipline, the matter will be dismissed or a cautionary letter is issued. The Commission may also rule that the registrant or certificant should do some form of education or remedial work or retraining. This can be either instead of or alongside any of the forms of discipline that we are about to discuss. Here are the forms of discipline that may be applied in cases where it is deemed necessary. Private censure. The Commission may order a private censure of certificants or registrants, which would take the form of an unpublished, written, and mailed reproach. Public letter of admonition. This is a more serious and more public form of reproach. It is where a letter of admonition is written and published in the form of a press release or in any other selected form of publication. In certain mitigating circumstances decided upon by the Commission, public notification may be withheld. Suspension. In an even more serious case, the Commission may issue a suspension. This happens when the Commission believes that the CFP certificate can ultimately be redeemed. There is usually a specific period of suspension that does not exceed 5 years. When a CFP professional is suspended, a public notice, such as a press release identifying him, is released. At the end of this period, the certificant has to reapply to use the CFP trademark. Revocation. This is when the offense is so serious that a certificant will never again be allowed to be a CFP professional or use the CFP marks. The standard procedure in this case is to publish the revocation along with the name of the disciplined certificant in a press release or other form of publicity that the Commission decides upon, unless there are extreme mitigating circumstances. As this is a permanent removal of CFP status, the certificant can never reapply for it. Discipline for candidates. Under certain circumstances, the Commission may also take disciplinary action with regard to the conduct of candidates for CFP certification. The disciplinary actions are similar to the 4 actions that we just discussed, but are applied slightly differently due to the differences in status between a certified CFP professional and a candidate for CFP certification. First of all, how do we define a candidate? Candidates are financial planners who have not yet received the CFP designation. Therefore, if necessary, subject to his meeting all of the other requirements for certification, a candidate could receive a private censure in his record. If he needs to receive a public letter of admonition, this will be published as applicable, and it will also be noted in his record. For a more serious offense, a candidate's certification application will be suspended for up to 5 years. Where necessary, his application will be permanently denied for more serious conduct. In such a case, the fact of the suspension or denial of certification will be published at the discretion of the Commission. It should be noted that in order to reapply for certification, if suspended, the candidate must meet the requirements of the original certification. Interim suspension status. So what happens while disciplinary proceedings are going on? Can the certificate carry on with business as usual? Not necessarily, according to the rules. The Commission is allowed to apply an interim suspension, which effectively means that the certificant or registrant would not be allowed to use the CFP marks for a definite or indefinite period until the proceedings have been resolved. This does not affect or preclude any disciplinary methods that may ultimately be imposed. A show cause order. What does a show cause order actually mean? The answer is actually found within its name. During civil court proceedings, if you are presented with a show cause order, it essentially means that you have to explain why a court of law should not follow a particular cause of action. You have to show a cause for the exception that you are asking for. In the case of CFP disciplinary proceedings, There are circumstances when the CFP's Disciplinary Commission will issue a show cause order. This happens when a certificant has been convicted of a serious crime, has been suspended, has appropriated property or funds, has indulged in threatening conduct, or has committed a grave offense affecting the stature and reputation of the CFP mark. In this situation, the CFP Board Counsel may ask for a show cause order to explain why the certificant or registrant's right to use the CFP marks can't be suspended while disciplinary proceedings take place. A show cause order is usually mailed to the certificant's or registrant's most recent address. A response must be sent back within 20 days from the date that the order is served. The certificant will either request or waive the right to attend a show cause hearing. The order to show cause will be considered to have been admitted, and an interim suspension will be issued automatically in the event that no such response is received. Once the response has been received, a hearing takes place before a quorum of the Commission. The certificant or registrant is allowed to participate, present, or hear evidence on his behalf. All evidence has to be submitted to the CFP Board no less than 20 days before the hearing. Any evidence that has not been submitted may only be admitted by motion at the actual hearing. If the certificant would rather waive the show cause hearing, he is allowed to propose an offer of settlement instead. Interim suspension. While financial crimes may not be as physically threatening as armed robbery, they are nonetheless dangerous to the public. It's a serious event if a financial advisor of any sort mismanages an individual's life savings. Therefore, if it is suspected that a certificant or registrant committed or was party to such a deception, the Commission has the right to issue an interim suspension while the matter is being investigated. The party in question can return to his position as a member in good standing when it is proven that he is innocent of the charges and does not pose a danger to the public, nor does his conduct negatively affect the stature and/or reputation of the CFP marks. It should be noted that even if a convicted or suspended certificant or registrant is appealing his conviction or suspension, this does not limit the Commission's power to impose an interim suspension. However, if the certificant or registrant is able to produce a certificate stating that the underlying criminal conviction or suspension has been reversed, the suspension will be removed immediately, as long as this reinstatement has no effect on any other procedures pending against him. Investigation. As a CFP certificant, ethical behavior is expected of you as an individual and is a major part of your job as a CFP professional. Should proceedings involving possible ethics violations be instituted against you, this would occur pursuant to an inquiry regarding the underlying facts. Such an investigation would be the result of a written request received by the Commission or at the request of the CFP Board Counsel. So, what actually happens when an investigation is carried out? Well, imagine that the Commission has received information indicating allegations of possible breaches in the rules of conduct. The first thing that would happen is the certificant would receive a letter from the CFP Board stating that he is under investigation. The certificant would also receive a general description of the allegations. He will be given 30 days to respond. If the certificant fails to respond, the matter is referred to a hearing panel. If a response is received, CFP Board Counsel compiles all of the relevant documents and starts probable cause determination procedures as soon as possible. What are probable cause determination procedures? This expression refers to whether there is probable cause to believe that grounds for discipline exist. In other words, might the certificant really need to be disciplined at this point? The CFP Board Counsel has several possible options here. They can dismiss the case and decide not to continue with any further investigation. They can dismiss the allegations, but send a letter of caution recommending remedial action or any other appropriate suggestions. Or they can begin preparing and processing a formal complaint against the certificant or registrant. It should be noted that even when a complaint is dismissed, the CFP Board Counsel may reserve the right to reopen the investigation in the future if necessary. Now, let's go on to see what the complaints process means and what it involves. Complaints. Issuing a complaint is the beginning of a process. The CFP Board takes complaints very seriously, dealing with them in a very fair and organized way. The CFP Board staff prepares the original complaint. Next, it is forwarded to the certificant or registrant. Copies of the complaint are also included in the material submitted to the hearing panel before the actual hearing. The Board lays out the grounds for discipline, as well as the original act of misconduct or omission upon which it is based. Then, the complaint is officially served upon the certificant or registrant by mail, with the return receipt sent to his last known address. All answers to complaints must be put in writing and should be received within 20 calendar days of the complaint being served. The original copy of this answer is forwarded to the hearing panel in advance of the hearing. The certificant or registrant should reply clearly to each allegation. Any mitigating circumstances or defenses should also be included in this answer. When an answer is not received within 20 days, the certificant or registrant will be considered to be in default and the allegations will be admitted. The CFP Board Counsel will issue an order of revocation, if we are talking about a CFP certificant, or an order of denial if this involves a candidate. The orders will outline exactly why the certificant or registrant has lost or will not have the right to use these marks. If this occurs, the certificant or registrant will have the right to appeal. Discovery and evidence. Our next step is that of finding evidence and proof. The certificant or registrant can obtain copies of all non-privileged documentation in his disciplinary file relevant to the pending action before the Disciplinary Commission. Requests for copies of CFP Board documentation must be made to the CFP Board Counsel in writing. Such information will only be released on the understanding that it will be used solely for purposes directly related to the disciplinary action. The CFP Commission needs enough time to sift through all evidence for a fair hearing. Documents that a registrant or certificant submits to the Commission for the resolution of the case can only be up to 100 pages in length. No evidence may be accepted less than 30 days before a hearing, unless admitted by motion. If you feel it necessary to exceed the 100-page limit, you must first submit a written memorandum explaining how each document relates to the allegations in the complaint. The Commission will decide which documents can be admitted after reviewing this outline. Witnesses. Witnesses can actually be called to a disciplinary hearing. They should be identified to the CFP Board no less than 45 days before the hearing. The certificant or registrant should state the nature and extent of the identified witness's testimony. The Board will also want to know if the witness will appear in person or speak over the telephone. The director of the review department and the chair of the commission review newly acquired information and make the decision whether to dismiss the case. Hearings. Now let's talk about what happens at a hearing and how it is carried out. Notice of a hearing should be given up to 30 days before it is due to take place. It should include the date and venue of the hearing. The certificate or registrant is advised of his or her rights. These rights include to be represented by a counsel at the hearing, to cross-examine witnesses, and to have the opportunity to present evidence on his or her own behalf. All hearings on complaints seeking disciplinary action should be heard by a hearing panel. All hearings must conform to rules of procedure and evidence as established by the hearing panel. These rules are not exactly the same as in a court of law, but the hearing panel can and should decide which such procedures should be applied. Proof of misconduct should be established through the evidence. Providing records or testifying on the grounds which violates the constitutional privilege against self-incrimination in a court of law may be upheld. The chair of the hearing panel is allowed to require an oath or an affirmation during proceedings. A complete record of all testimony given at a hearing panel is made. Reports, findings, and recommendations. Once the hearing is over, the hearing panel records its findings and recommendations. It submits all of its conclusions to the Commission for its consideration. Any prior disciplinary records may be taken into account. After the hearing panel's report to the Commission, two things may happen. Either the panel determines that there is no basis for the complaint, or that the established facts don't require any disciplinary action. In either case, the complaint will be dismissed either as without merit or with a caution, depending on the circumstances. Or the matter is referred to the Commission with the recommendation for disciplinary action. The hearing panel states which type of discipline it deems appropriate in this case, and it may recommend that the Commission add other requirements. The Commission reserves the right to review any orders or recommendations made by the hearing panel. It can enter a request directing further proceedings. The Commission can also either review or modify the hearing panel's report. It should accept its findings as fact unless it has ruled otherwise. It can also modify the hearing panel's recommendations without reviewing the record, but has to give clear reasons for the modification. Once the Commission has issued an order, the certificant or registrant has the right to submit an appeal to the CFP Board's Appeals Committee within 30 days. The order becomes final once no appeal is received within this time period. Conviction or professional suspension. Official documentation from any criminal court or governmental or self-regulatory authority stating that the certificant or registrant was suspended or convicted is sufficient proof of the happening and will be included in the Board's review. A certificant or registrant is obligated to inform the CFP Board within 10 days of notification if he is convicted of any crime apart from a traffic misdemeanor, unless it involves drugs or alcohol, or if he is professionally suspended. As soon as notification of any conviction, other than for a serious crime, which we'll talk about soon, is received, CFP Board Counsel launches an investigation. Remember the show cause order that we spoke about earlier? A certificant or registrant is immediately suspended from using the CFP marks once convicted of a serious crime or if he is professionally suspended. The CFP Board Counsel can, however, issue notices to the certificants or registrants asking them to show cause as to why they shouldn't have their rights to use the CFP marks revoked or suspended. The next question is, what is defined as a serious crime under these circumstances? Included within this serious crime category are any felony and also any lesser crime that involves one of the following: misrepresentation, fraud, extortion, misappropriation, or theft. Also included within the category of serious crime is any attempt or conspiracy to commit such a crime or the solicitation of others to do so. It's also useful at this point to define a professional suspension. This is when the suspension or bar is applied as a disciplinary measure by any governmental or self-regulatory body of a license as a registered securities broker, dealer, representative, insurance or real estate salesperson, broker, accountant, attorney, investment advisor, or financial planner. An offer of settlement. Sometimes the parties in a dispute may offer a settlement in lieu of disciplinary proceedings. This can only be done in circumstances where such a settlement would be in the interest of the CFP Board and the public. Such an offer must be made in writing and must be submitted to the CFP Board at least 30 days before the hearing is due to take place. The hearing panel will then consider the offer. Remember, only one offer of settlement can be made during any disciplinary proceeding. This offer must not be frivolous. It should be compatible with the seriousness of the alleged disciplinary violations. The CFP Board Counsel can also negotiate the settlement with the certificant or registrant and then endorse it with the hearing panel. Only the Commission is allowed the final say on whether or not to approve an offer of settlement. What is an offer of settlement? Now that we've talked about the how, let's get to the what. What would we expect an offer of settlement to include? Within the proposal should be the following: a description in reasonable detail of the act, practice, or omission that the certificant or registrant is alleged to have committed, a statement regarding which regulation, principle, rule, or practice standard this act, practice, or omission has violated, a statement that the certificant or registration consents to the findings of fact and to the violations that have been described, proposed Commission action to be taken, and a statement that the certificant or registrant agrees to this action, and a waiver of all rights to appeal the CFP Board's Appeals Committee and to the courts or to any other type of challenge to the order or its validity once the offer of settlement has been accepted. Acceptance or rejection. What happens next? Let's imagine that the hearing panel has accepted your offer of settlement. The Commission then has to review the hearing panel's decision. Proceedings on the matter are concluded as of the date that the offer gets accepted once the Commission has decided to approve this decision. On the other hand, the hearing panel may decide to reject the offer, and then the offer is considered void. The matters raised in the complaint will then be discussed at the next meeting of the Commission. The rejected offer of settlement doesn't cast any shadows over the deliberations of the hearing panel or Commission. Another possibility is that the hearing panel can make a counter-settlement offer. It can modify the findings of fact, violation, or discipline. If the certificant or registrant rejects this new offer, this is also considered void. Similarly, this doesn't cast any shadows over the next meeting of the two parties to discuss the complaint. Again, if a revocation or suspension is issued after all of this, it will be publicized, along with the identity of the certificant or registrant, in a press release or any other form of public notification that the Commission decides upon. Certificants or registrant may not use marks in advertising, letterheads, logos, or business cards after a revocation or suspension is final. Reinstatement after discipline. The certificate or registration can never be reinstated following revocation. Suspension, on the other hand, is only a temporary measure. Consequently, one is able to be reinstated afterwards. Hopefully, during the time that you were suspended, you have learned from your mistakes and you are ready to return to life as a CFP professional. In cases where suspension is only for a year or less, you are automatically reinstated at the expiration of this period. Remember to contact the CFP board within 30 days of this date and state that you complied with the suspension and other disciplinary procedures. For longer suspensions, there will be a reinstatement hearing. You have to apply for reinstatement at least 6 months before the end of the suspension period. Before a reinstatement hearing is scheduled, the certificant or registrant has to meet all requirements for recertification, pay the costs of the hearing, and, if necessary, provide evidence that prior hearing costs were also met. This hearing is a chance for you to prove that you have learned from your mistake, have complied with all disciplinary action, and are fit to use the marks again. CFP Board Counsel also conducts an investigation into the petition for reinstatement. The certificant or registrant should comply with this. Then the CFP Board Counsel will make a recommendation to the Commission. The Commission will report on the certificant or registrant's previous disciplinary record and make any recommendations of its own. If the decision is not to accept this petition, another petition can be made 2 years later. It must be received within 6 months before the end of this 2-year period. Failure to submit the second petition within this time frame means that the marks will be administratively relinquished. If the second petition is also refused, the petitioner will never be allowed to use the CFP marks again. Petitioners for reinstatement are assessed the costs of the reinstatement proceedings. The right to silence. In general circumstances, details of the proceedings and hearings are confidential. The CFP Board Counsel records, staff, hearing panel, and commission are not made public. Under the following circumstances, the subject matter and status of proceedings may be disclosed. 1. If the proceedings follow a criminal conviction or professional suspension. 2. If the registrant or certificant has chosen to waive confidentiality. 3. If it's necessary as part of a legal process at a court of law or to comply with a request from a governmental regulatory body. And 4. If these proceedings involve a consumer, the CFP board may contact the consumer and the certificant or registrant's current or former employer for any relevant documentation. Now that we have discussed the subject of disciplinary hearings at length, here are 1 or 2 further points that we may not have touched on. Costs. Who pays? The Commission assesses the costs against the certificant or registrant in all disciplinary cases involving a hearing. Moreover, if the certificant or registrant requests an appearance either in writing or by telephone, or submits an offer of settlement, he must also pay hearing costs no less than 30 days before the scheduled date of the hearing. The costs will be returned to the certificant or registrant if the result of the hearing is that the proceedings are dismissed without merit. There's no refund if there's any other type of outcome. In the same way, anyone who applies for a reinstatement hearing also has to bear the cost. But what if the certificant or registrant can't afford to pay? Then he sends a written request with a description of his financial situation to the CFP board, asking for a deferral, reduction, or waiver of the hearing costs. This must be more than 45 days before the hearing, and the CFP Council will decide which form of action to take. In today's computerized world, documents requiring a signature may also be submitted electronically through the CFP board's closed website. Any such document requires proof, however, that the certificant or registrant whose name appears on it actually submitted it, and that the certificant or registrant is bound by the conditions specified within it. Such a document is as legally binding as if it had a handwritten signature. Candidate fitness standards. If you are planning to apply for CFP board certification, it is important to remember that there are certain specific standards of character and fitness that must be adhered to in order to maintain the positive reputation of the CFP certification marks. It is a good idea to know what these are before you think of taking the examination for certification. Here are a list of offenses that will always bar an individual from being accepted for CFP certification. 1. Any felony conviction for embezzlement, theft, or other financial crimes. 2. Any felony conviction for tax fraud or similar tax-related offenses. 3. The revocation of any professional, financial license unless this is solely because the individual didn't wish to renew this license and therefore didn't pay his fees. 4. Any felony conviction for murder or rape. 5. Any such conviction for a violent crime within the past 5 years. And 6. 2 or more personal or business bankruptcies. Below is a list of circumstances where the candidacy would be presumed to be unacceptable unless the individual petitions the Commission with the request for reconsideration. 1. One personal or business bankruptcy filed in the past 5 years. 2. More than one judgment lien. 3. The revocation of a non-financial professional license, unless, again, it's simply because the holder left it to expire as he didn't wish to renew it. 4. Suspension of a financial professional license. 5. Felony conviction for a violent crime, including perjury, within the last 5 years. And 6. Any convictions for violent crimes other than rape or murder that occurred more than 5 years ago. Other issues will be reviewed by the Commission. Furthermore, the CFP Board will require candidates for CFP certification to disclose certain ethical issues within their initial certification application. Okay, well, that's it. We have now gone through the CFP Continuing Education course for Ethics. Thanks very much.
Thank you for joining us for this continuing education class. If you have questions regarding the materials, please feel free to email the instructor, Doug Goldstein, at doug@profile-financial.com. Now, in order to get your CFP Continuing Education credit, please return to our website to complete the required exam, www.ce-institute.com.